Welcome to Hull on Estates, a series of podcasts for the Canadian legal community dealing with issues and insights surrounding estate planning in Canada. Hosted by the lawyers of Hull and Hull, the podcast will touch on some key considerations when planning estates and wills. Now, here are today's hosts.
Hi everyone, I'm Sydney Osmar and welcome to Hull on Estates. You're listening to episode number 718 and I'm here today with...
Hi everyone, my name is Boris Eng.
How are you doing, Boris?
I'm doing well. How are you?
I'm good. I'm glad the weather's finally turning around and we're getting some sun finally.
Same here. It's been a long winter and it's nice to have some sunlight.
Yeah, for sure. Well, for our listeners, we thought today would be a good time for us to talk and have a little chat about collaborative practice. So I think Boris was interested in learning more about it, and so I think he's prepared some questions for me. So I'll pass it over to you, Boris.
That's right, Sydney. This is a topic that's come up both in my professional life, getting questions from other lawyers about it, and as well personally. So yes, I just want to dive right in. I got some questions that might provide some insight to the process for our viewers. So why don't we start off by asking about the collaborative law in general and how it kind of differs from traditional litigation?
Collaborative law and collaborative practice, it's really a form of alternative dispute resolution as opposed to the traditional litigation or adversarial techniques that you would find in litigation. It's a process that you would hopefully, enter into with your clients before litigation has started. Hopefully you can resolve before they need to go into litigation. And it provides a framework where you have a commitment from both the parties and the lawyers to work collaboratively and cooperatively, to have, full disclosure and information sharing, and to have an interest-based negotiation. And one of the key things about collaborative practice that kind of sets it apart from other alternative dispute resolutions, especially in how it's been practiced in the family law world, is at the outset there's an agreement that if the collaborative process fails, the parties would actually have to fire their lawyers and retain new litigation lawyers to be able to continue their claims in the traditional adversarial context. There's a pretty big ethical discussion around that, and debate on it. I know there's been some pushback on that from the estates bar perspective, for those interested in trying to bring it into the estates bar world. But that's a whole other conversation. For a little more background, collaborative practice is something that's been happening in the family law world for decades now, and it's been quite successful there. And there's some cross-pollination, I guess we'll call it, is starting to happen where it's spreading into the civil bar. And there's a group of us at Hull and Hull and other leaders from our bar who would really, really like to see this come into the estates world, as another toolkit for us to try and help clients resolve their disputes as efficiently and cost effectively and just as best as possible for them in a way that doesn't destroy family units, and to try and keep them out of a super backlogged court system.
Mm-hmm, mm-hmm. Very interesting. So it sounds like from what you've told me, it is very non-adversarial. They're looking for collaboration. It's right there in the name. When are instances when collaborative law when is it appropriate and when is it not appropriate?
Yeah, so one thing, and I do have to preface it with, I personally am not yet collaboratively trained. We are, and we can talk about this later, going to be having a collaborative training for estate practitioners happening in November. But based on my consultations and outreach with family lawyers and civil practitioners, and I've even spoken to a lawyer out in Australia, Zinta Harris, who's doing it in Australia in an estates context. And so when I'm speaking, it's not from my personal experience, it's just from the very helpful and knowledgeable feedback that I've been getting from those who are actually doing it. And so through those discussions, we've learned that, the collaborative process may isn't appropriate for clients who are not prepared to have to have full disclosure of documents. If they want to come into the process and hide or keep information from the other party, it's not workable. There's no way that the process would work. Um, the parties have to have a commitment to want to negotiate and settle. And if it's really just being used as a way to further delay or increase costs, then that's also not going to be appropriate in an appropriate situation. It may also not be appropriate in, if there's a circumstance of elder abuse or a situation where there's just an extreme power imbalance that can't be corrected. Then that situation may also not be appropriate if the imbalance can't be corrected as part of the process. And so some of the feedback that we've heard from the practitioners who are successfully involved in the collaborative process in their respective fields is that a very key step to the process is the intake that you do with the clients when they come to you, to assess whether or not it's appropriate. In some instances, we've heard they actually have. So in the collaborative process, you have. I mean, there are different types. There are types where it's collaborative law. There's two collaboratively trained lawyers, and they go through the negotiation process with the clients. And there's also a team approach where you would have two collaboratively trained lawyers or more if you have more than two parties. And then you would also have collaboratively trained neutral professionals. So you would have a financial neutral, you would have a mental health professional, and the team would work together with the clients to come up with a settlement, hopefully. And so I know in some people, they actually have the mental health professional do the intake with the clients and make the assessment on whether or not they think that they'd be suitable for the collaborative process. But that initial sort of intake and information gathering would be key to being able to triage and assess whether or not that they'll ultimately be hopefully successful, or if the process is suitable for them.
Hmm. So that sounds like that was the outset of the process of it. The very beginning is very important. You're trying to determine if this is appropriate. If it is, what is the next step in the process? I believe there is a participation agreement that might differ a little bit from retainers.
Yeah, so I mean, you would have a retainer with your client, and they'd obviously, have to be fully informed on the process and consent to it. So you'd have that informed consent moving into the process, which is particularly important if you are going to have built into that retainer that if the process fails, they have to fire you and retain a new lawyer. They need to be kind of fully informed on that before they consent to it. But the next big, I guess, well, I mean, if you think of mediations, you have a mediation agreement that the parties enter into before they go into the process. So kind of similar to that, you have what is referred to as a participation agreement. It's a little bit different than a mediation agreement, though. Usually in that context, it's sent out by the mediator's office. The parties, you review, you sign, you move on, and you go to your mediation. With the participation agreement, it's going to fully set out the process from start to finish. It's going to ensure that the parties are all on the same page with regard to the process. So you would work out with the parties at that initial stage, especially like the way we've looked at it from an estates context, because sometimes we do still need to involve the court for things like production orders or things that can be obtained on consent that you require an order for, so the court's involvement is necessary. You would want to build into that participation agreement a process for that. So, what consent orders have the parties agreed to? Who's going to pay for it? Is it coming from the estate? Is it coming from the applicant, or the would-be applicant, or is it being split between the parties at first instance? Like you would be able to work out all of that. You would have clearly set out the disclosure agreements between the parties. and that commitment to work cooperatively with one another. And that, if once you've made your disclosure, if new information comes to light, you have an obligation to continue to keep that disclosure up to date. Um, and it's really kind of the backbone to the process. It sets out what you'll be doing and how you'll be doing it and what everybody's agreed to.
Mhm. And so, how can collaborative law be beneficial to our specific area of practice, as in like the state's disputes and the state litigation?
Yeah, so something, I mean, like I mentioned, it's been practiced in the family law world for decades now, and in our consultations with those who are doing it, the feedback has been that it's been, you know, extremely beneficial to the clients, but the lawyers themselves also. You're able to have families work out their issues themselves with the guidance and the assistance of the professionals around them, but it really is a client-driven, client-focused process. The parties are, with the assistance of, for example, the mental health professional, they learn about their own communication styles. They learn, they get coaching from their lawyer on how best to negotiate for themselves. And it provides a setting and a process that hopefully avoids the sometimes full scale family breakdown that can happen in litigation. And it also hopefully provides a platform for people to be able to take control of their own issues and find a resolution that works for everybody, find a win-win solution versus a win-lose situation, which is what often happens in litigation.
That's right.
And so when you kind of look at those broad strokes, um, pros and benefits of the process, and you think of family law and the similarities between family law and estate law, insofar as the context of the families that you may be dealing with and the different issues and emotions that can come to play. There's a group of us that feel it would be something really well suited for estate disputes. I'm sure, as many estate litigators, you can think of situations where, you know, just like communications and have inflamed things, and the parties they're not necessarily explaining themselves in a way that they could if they had some assistance on how to kind of break down what their true goals are, and bridging that gap with their siblings or their family member. And so we've kind of looked at it, and we could see it being helpful in um, passing of accounts matters and guardianship disputes, where the family, everybody at the end of the day wants to do what's in the best interest of their parent, for example, but they just can't quite figure out amongst themselves the best way to do that, and there's fighting. And then you end up in court, and you have a decision being made from a judge who isn't necessarily apprised of all of the inner workings of the family. Where if you're in a collaborative process, you're working with a mental health professional, the parties are there together, they know the ins and outs of their families and what may or may not work for them, and hopefully you'd be able to work out something um, that works for everyone without having to go through an adversarial process. As I mentioned, there will still be situations where the court involvement's necessary, for approvals of settlement, um, production orders, extensions of limitation periods under the Family Law Act if you need them. There are going to be things where you still need to involve the court, but it can be done in a consensual way, and built into the process, and still allow the parties to or the clients to drive the settlement. Um, but yeah, so when we kind of learned and looked at it more, we were like, we really want to try and bring this into the estates world. I know an effort was made, I think 15 or 20 years ago. Ian was involved with it back then, and it unfortunately didn't take off. But we're hopeful that this time around we've done our research, we've got trainers in place, and I think even just like the legal landscape itself has shifted in the last 15 to 20 years around ADR techniques and mediation, and with the court backlog too. I think there's a big push for trying to be able to provide clients with a way to resolve disputes without having to go, down a war path with hundreds of thousands of dollars of legal fees and years later.
Right, right. And I find that this particular ADR is very interesting to me because we are trying to maintain the family relationships, and that's like a core I think, problem in estate law that leads to longer delays and costs. And so I think this is a welcome change and something that I'm looking forward to learning more about and maybe even specializing in. So on that note, for estate practitioners like us, what kind of special training do we require, or are there programs or sessions we can attend to prepare for the coming of collaborative law?
Yeah, so it's something that it's a passion project here at Hull and Hall. We've been working on it for the last quite a while now, in consulting with people, and we've worked and reached out to trainers who have been doing the training in the family law world, and so it's Victoria Smith and Laurie Stein, and they're helping us put together a training that has been amended and kind of uh, in a more of a bespoke way, I suppose, for the estates bar to kind of reflect the intricacies and differences of our practices. Because, like I said, there are similarities, but there are some differences. The main one being that, oftentimes we will still need the court's involvement to a certain degree. There are, of course, other things that we're working through and trying to figure out the best way forward. But so we in collaboration with Victoria Smith and Laurie Stein will be providing a 2-day training for estate practitioners who are interested in collaborative practice and want to get collaboratively trained. And that will be on November 13th and 14th. It's going to be happening at the National Club in Toronto. Given the nature of the training, it does have to be in person. And then from we'll be sharing more information on the actual registration, and we'll have a link to do that. We hope to have that all launched mid to end June. So if you're interested and want to have, if our listeners are interested and want to learn more about it or be added to our interested participants list, they can reach out to me. Of course, also Ian Haller, Susanna Popovic-Montag, or Mark Lawn. Those are the kind of the 4 people at Hull and Hall who are trying to spearhead this project. And you can go into our website for emails and reach out to any of us if you want to be added to that list or just learn more about what it is that we're doing. Insofar as like training and accreditation in the family law world, so there's the Ontario Association of Collaborative Professionals, and they have specific training requirements set out for family professionals, and depending on the group and the requirements, the training, I understand, can be between 2 to 5 days, and then there's additional hours that you can put in. But for estate practitioners, because this is new, it doesn't exist yet. We've got the 2-day training set up, and we'd like to kind of keep the movement going on from there. We'd like to have some ongoing webinars and resources shared and training and things like that, so that people can kind of continue with it and bring it in successfully into the estates world this time is the goal and the hope.
Well, I also hope that we will succeed this time, and that sounds like a great program that I'm interested in as well, and something to look forward to.
All right, well, thanks so much, Boris. It's been great. I think we've covered off a lot, but like I said, if any of our viewers have any other questions about it and want to be involved or learn more, they can feel free to reach out to myself or Ian, Susanna, or Mark. But for now, I think we'll just wish our listeners a good rest of their weeks. And thanks again, Boris. I hope you have a good day too.
You as well. Thank you so much for your time, Sydney.
Thanks.
This has been Hull on Estates with the lawyers of Hull and Hull. The podcast you have been listening to has been provided as an information service. It is a summary of current legal issues in estates and estate planning. It is not legal advice, and you are reminded to always talk with a legal professional regarding your specific circumstances. To listen to other podcasts or to leave a question or comment, please visit our website at hullandhull.com. Our theme music is Upper Structure by DJ A Kid and is courtesy of the PodSafe Music Network.